Your Honor.
Thank you. Good morning, Council. Before we begin, I'd first like to note that Justice Keller has recused herself from this matter and will not be participating in any way. Secondly, I would like to take a moment to educate those who may be watching this live stream proceeding as to the reasons why the Connecticut Supreme Court has notified Council to appear for today's status conference in response to the Reapportionment Commission's petition that was filed on December 2nd, 2021. In short, the Connecticut Constitution directs that absent a timely agreement by the Reapportionment Commission, the Connecticut Supreme Court becomes part of what is essentially a political process. As Council knows, the petitions were filed in this court in 2001, 2011, and now again in 2021. On December 6, 2021, notice was issued ordering your appearance at today's status conference to address the Commission's petition. The petition asked this court to remand this matter to the Reapportionment Commission pursuant to Article 3rd, Section 6 of the Connecticut Constitution as amended, and to grant the Commission until December 22nd, 2021 to complete its work by submitting a plan of redistricting for the state's congressional districts to the Secretary of State. Our case law reflects that this court is an institution particularly ill-suited to undertake this role. We are therefore hopeful that the Commission will complete its work. You may, however, rest assured that we will do our job if the Commission cannot come to an agreement. I also want to make it crystal clear in the event that we are required to take on this task, the court is completely uninterested in the political results of the reapportionment. In preparation for today's conference, this court asks you to be prepared to address and provide the following: the status of the Commission's consideration of the alteration of the state's congressional districts. 2, the Commission's views on the following: A, whether the court should appoint a special master to assist the court in this matter. B, if so, the factors to be considered in appointing a special master. C, the process and procedures to be employed by the special master. D, the scope of the duties of the special master. E, the legal and policy parameters governing the redistricting map to be proposed by the special master. And F, if any other matters deemed relevant by the Commission. 3, an interim report detailing the progress of the alteration of the congressional districts. This court also indicated in the notice of December 6th that the court retains jurisdiction of this petition and will issue dispositive orders in due course after the conclusion of the status conference. At this time, please proceed and address the items that I just read into the record and that were contained in the notice that you received.
Thank you, Your Honor. Maura Murphy Osborne, Assistant Attorney General for the Commission. Your Honor, I'm pleased to report to this court that the Commission is not at an impasse, that if this court provides the reasonable extension of time and remand to December 21st that the Commission has requested, the Commission is hopeful that it will reach an agreement on the remaining point, which is the congressional lines. As Your Honor is cognizant, and the entire court is cognizant, the Commission has had to perform its duties this year under very challenging circumstances. It has operated under a very compressed timeline due to the approximately 4-month delay in receiving the census data from the federal government. Notwithstanding that compressed timeline and those challenges that have been posed to everyone in government this year, the Commission has completed the plan of districting for the state General Assembly lines, and it remains hopeful that it will complete this final piece of redistricting, which is to reach an agreement on the congressional lines and the congressional map. To that end, Your Honor, the Commission members are exchanging proposed congressional district maps with each other this Friday. The Commission and its staff will continue to work through the weekend, and it is the Commission's intention to respond to the members' differing proposals, to the extent there are differing proposals, and to exchange ideas regarding the congressional lines on or before next Tuesday, December 14th. So that is the response to the court's order as to questions 1 and 3, I believe, and if as to if there's anything on that further, I'll move to addressing your paragraph 2 in your order.
Thank you. Do any of the justices have a question at this point? Thank you. Please proceed, counsel.
Thank you, Your Honor. As to paragraph 2 of this court's December 6th order, the Office of the Attorney General is not authorized at this time to represent the Commission on those substantive questions raised in that paragraph 2. Our representation at this time for the commission was to submit the petition to seek more time for the commission to complete its work. However, given the court's focus and its diligent work in completing its work to finalize the congressional lines, and the fact that the members are not at an impasse and that they remain hopeful to reach an agreement on the congressional lines, we believe that the court may not need to address those questions in paragraph 2.
Counsel, there's a question from Justice McDonald.
Good morning. So first, I should point out that because of the unique circumstances of this, we are not in a adjudicative capacity. We're in a legislative capacity. Is that correct, Counsel?
The Constitution does accord original jurisdiction to this court once the November 30th deadline is not met and the Chief Justice received the report from the Secretary of State. So the constitutional provision does give this court broad authority to take any action to effectuate the purposes of the constitutional provision.
So let me ask you this question. The petition is pretty narrow at the moment. It is just for an extension of time. And the window to file petitions expires on December 30th, right?
There is a 30-day deadline for a petition to be filed from the date of any duty under that section.
So if we grant this petition, that's all the relief that's being requested. Is the commission contemplating, if it meets with a plan, is it contemplating filing a subsequent petition before December 30th?
I cannot answer that question.
Well, that's my concern. If we grant the extension, arguably we lose jurisdiction at that point because it's all the relief that's been requested in the petition, right?
We read the constitutional provision to accord this court broad authority at this point and to enable it to retain jurisdiction even if this petition is granted.
Okay. Do you have authority for that?
The language of the provision which says, or said court may take such action to effectuate the purposes of this article. Subsection D vests this court with original jurisdiction to be exercised upon a petition which you have received. You have received a petition of registered voters, and this provision states very broadly your authority.
Okay, so in your view, regardless of whether an elector has filed a petition, we have authority separate and apart from any petition before us to create a plan and file it before February 15th. Is that right?
If I'm understanding your question correctly, I don't know that I entirely agree with how you framed it. I believe that this court's jurisdiction is exercised upon, this court's original jurisdiction is vested under the provision, and it's to be exercised upon a petition of a registered voter, which you have before you.
And that's exactly my point. I mean, the petition asks only for time. If we grant the time, that's all the relief that's being asked for in that petition. Is that petition then completed and we no longer have original jurisdiction because all the relief that was requested was already granted?
The petition is a petition for remand, and we believe that the court can retain continuing jurisdiction now that it has received this petition.
Okay, so in your view, we could grant the 3-week extension and remand it, but we retain jurisdiction at that point, regardless of whether any new petition is needed. Is that right?
That's our view, yes.
Okay, thank you.
Justice Doria.
Thank you, Chief. We also, some of our questions are going to be because we have uniquely happen to have maybe the only lawyer in the state that knows anything about this in front of us. So if you have to ask us, if you have to beg off some of these questions, that's fine. But can I ask you, based on your familiarity with how the court handled this with Professor Purcelli 10 years ago, I mean, we're really just talking about congressional districts here, and maybe you could disabuse me of the notion that I think that this could be rather simple for the commission or for us to do, because there's only 5 districts and they have to be equal, and you don't have town integrity principles like we do with our state house districts. So, I mean, I guess you're begging off of that, of advising us whether to hire somebody to do this. I respect that, but could you give us any sense, from your experience, any sense of whether that's a really challenging thing for us to do? I mean, if the chief is sort of presaged that we're not going to pay attention to politics on this, so we could just sort of divide up the state.
I cannot really provide guidance on that. I would just reiterate the hopeful guidance from the commission that they're not at an impasse, which may reflect some of what you just indicated, may flow from some of what you just were discussing, the fact that they're not at an impasse.
Okay, thanks.
Justice Mullins and Justice Kahn.
Thank you, Chief. I just wanted to follow up briefly on some of Justice McDonald's questions and how you see us exercising our jurisdiction. Do I understand you to be saying that we have to, is it necessary to grant the petition? Like, once our jurisdiction is invoked and we can now exercise it how we deem appropriate, do we need to affirmatively grant the petition, or can we hold the petition in abeyance now that it's been filed and exercise our jurisdiction to say, hey, we want a status report, let us know what's happening, without a formal up or down on your petition for more time? Is that how you see it?
No.
Okay.
I believe this court should grant the commission's petition, December 2nd petition, and should make clear on the record to the Chief Justice's opening remarks that this is a political process. It should be appropriately remanded to the political body that has the duty in the first instance to complete it. And I think that both for that reason, and then also just to remain consistent with how the court has handled these matters in 2001 and also in 2011, where the court clearly granted and remanded to the commission. I believe the court should maintain that practice. In 2001, it was the court never had to take up the matter again, and in 2011 there was an orderly process, and the court was able to meet its February 15th deadline when it did ultimately have the obligation to file its own plan with the Secretary of State.
But correct me if I'm wrong, if you remember, I get these dates mixed up, but in 2011, wasn't there also a petition by an elector, like a private citizen? It wasn't just the commission asking for more time, was it? Do I have that mixed up?
My recollection is at this stage, it was just the commission asking for more time. There were later on in December of 2011, there were other petitions filed by other individuals. Or let me also correct that. I think I just looked at Exhibit A to what we filed with you, and you'll see that the court, when it granted the commission's petition and remanded for the additional days, it said in the decision that for that reason it didn't need to take up the petition of an individual. So I just am not recollecting that particular thing, but I just recollect clearly that at this early juncture, when the commission was just asking for a reasonable extension of time, as it is this year, that it was not overly complicated, I guess is what I'm trying to say.
I'm just curious, and this is my last question for you, because it highlights, I think, what Justice McDonald's saying, at least in my mind, in that there was a petition by Mr. Munn, I believe it was, pending. So we no actioned his petition and granted time for the commission. So we had a petition that was there. This would be if we granted your petition, or the commission's petition, that would be the relief that petition is seeking. So it highlights in some ways Justice McDonald's questions of, so what do we do? What are we left with after that? In terms of jurisdiction, this, you know, you're asking for more time. We say you got it. That's the petition that invoked our jurisdiction.
Well,
before, there was at least the private parties or an elector's petition also pending that we just no action that would seem to still be viable. We could pick it back up.
yeah, I read the court's order in 2011 where it said no action is required on the petition of Paul Munns at this time, as you know, denying it as moot. Essentially, that's how I read it, but perhaps you're reading it a different way. But moreover, I think that the very broad language in the if I see Justice Khan has a question, but so I can stop. But if you would like me to continue, okay. So the very broad language that of the provision that says, you know, in subsection D, or said court may take such other action to effectuate the purposes of this article, we read that as including retaining jurisdiction. You know, once you have the petition of a registered voter, which you have, you can take really any action to effectuate the purposes of this article, and to the extent you need to retain jurisdiction to ensure that come December 22nd, if you don't have a plan, you need to then embark on that process whereby the court shall prepare its own plan and file it by February 15th. You are in a position to do that. And then I would just say, practically speaking, the likelihood of you not receiving another petition from another registered voter is probably pretty low.
Thank you.
Justice Khan?
Thank you. Thank you, Chief. My questions are really also a follow-up to what Justice Mullins has just been asking you, and Justice McDonald. I have a slightly different sort of hypothetical for you. You would agree, would you not, that the commission, even though its time has lapsed, even though we've not acted on the motion, they are proceeding with their work from your report?
That is correct, yes.
So it's not an impediment for them to continue their work, even though we've not acted on the motion for extension of time?
I don't know whether it's impeding them in any way. Any degree of uncertainty is probably not welcome.
Okay. And based on your report, it sounds like the commission is working towards at least some progress, hopefully to have an agreement either this weekend or by Tuesday. Would you agree with that as well?
My report on the status is that they are continuing to work through the weekend. I am not intending to indicate that they expect an agreement by the weekend.
Right.
And that there will be, their plan is to have a scheduled exchange of ideas and perhaps concrete proposals on Tuesday. So I would say Tuesday or Wednesday would be the earliest.
So I had 12/14 or as the exchange date. So I see your point. They're working through the weekend. Maybe they'll have something by 12/14. My question is this: what if the court were to, rather than hold your request in abeyance, grant it in part, and let's see what they can come up with on the 14th. And the court, there would be no issue of jurisdiction. I understand your position is that we retain jurisdiction, but if the court were to grant it in part and hold the remainder of the time in abeyance, would that present the problem that you raised with Justice Mullins? Question, which was hold the entire, his question was, what if we hold the request in abeyance? And you seem to indicate that that would not work because the commission needs the grant of the request. And I'm wondering if, given your report, that there may be something by the 14th or 15th as early as that, would it address Justice McDonald's concern, very legitimate concern, do we retain jurisdiction then?
It's the commission's view that their petition should be granted. And that this is first and foremost their duty and their obligation, and it is a duty and obligation appropriately vested in the political branch. That's the commission's view, and that has been the historical practice. And we believe it's both appropriate and preferred to grant the petition outright for those reasons, and that the petition is not an impediment to this court retaining jurisdiction.
And so I understand your position. Justice McDonald raises some very legitimate concerns, as has Justice Mullins. And as the chief said at the outset, I agree with you. It is not, this court is not a political body, and this is a political decision. But I guess what happens if, come the grant of the extension, nothing happens, and then, the clock is ticking in terms of time.
Would you like me to answer that?
Yes, please. And that's my last question. I noticed my colleagues have questions, and I would turn it back over to the chief to call on them. If you could answer that, that would be great. Thank you.
That is what happened in 2011. The extension of time was granted. The commission at that time was at an impasse, and they didn't resolve that impasse by the December 21st deadline. So that is what happened. And notwithstanding that the court undertook to retain a special master, it retained a special master with expertise in reapportionment. And it did so in consultation with the commission members, is the best of my recollection, that names were submitted and the court selected a special master. The special master then engaged in open and transparent public hearings at the General Assembly through January, timely submitted a plan to the court. The court acted upon it, and the court comfortably met its its February 15th deadline. I believe it issued its ruling on, not December 15th, excuse me, February 15th deadline. I believe the court issued its decision on February 12th with 3 days to spare. So, so that is what happened. It's not the preferred approach. It is preferred that the legislative body that it has this duty complete its work. And that's, we're hopeful that is what will happen this year.
Thank you. Thank you, Chief. I yield back to you.
Justice McDonald, then Justice Ecker.
Thanks, Chief. Counsel, I mean, I understand you're hopeful. I think we're all hopeful, but it's better to plan for the worst and then be surprised. So let me ask you this: why wouldn't we pursue parallel paths at this point, with the commission continuing its work and us going about the process of actually lining up a special master to assist the court in the event that the commission fails to come to an agreement? I mean, my point is, you said that they're not at an impasse. Fair enough, but they haven't even exchanged maps yet, and so they don't know if they're going to be at an impasse. So why wouldn't we just plan for the worst and then hope for the best?
Well, I don't know that I represented that they haven't exchanged maps at all. So I'm not, I can't,
I thought you said they were exchanging them on Friday.
but I just don't know that if that's the first time they've exchanged maps. So I don't know. I can't represent that. I know maps are hoping to be exchanged on Friday. Whether that's the first iteration, I cannot speak to that because I don't know. So I don't want to misinterpret what may have already transpired. As to your question about whether the court should pursue a parallel path, that is for the court to decide, and is for the court to determine whether that's in keeping and appropriate with its role as a non-legislative body. So.
Thank you.
Justice Ecker?
Just a logistical question, I think, following up on something Justice Khan asked. Is there something, if the court were to decide, for example, that it didn't want to, for whatever reasons, extend time until the full amount of time, but wanted to do a few days less or something like that, is there anything magical that you know of about that date that was requested by the commission? Are there some events occurring on the 20th or 21st or something, or was it just, well, 3 weeks about sounds about right or something?
I think in answer to your question, there is nothing magical about December 21st. I guess the benefit of December 21st is that it is in keeping and fully consistent with the historical process, to the extent additional time is needed. So, and moreover, just keeping with that historical practice and that consistency, it probably doesn't meaningfully impact the court's ability to undertake the creation of its own plan should that come to pass.
Okay, great. Yeah, I'm not suggesting that it's an excessive amount of time or anything like that. I was just wondering if there are any jurisdictional questions, if that would leave us a way to satisfy ourselves. But I thank you for your answer.
Yes, thank you, counsel. I happen to notice that December 21st is the shortest day of the year and the beginning of winter, and I hope that's not a bad omen. But going back to your conversation, your dialogue with Justice McDonald, I think we're in this sort of an unusual position that we've had a pandemic, we've had a lot of issues come up in the last couple of years, and now we have this, and hope is just not a plan of action. So I'm trying to figure out what we need to do our due diligence and to run on a parallel path. And I guess we'll have to work that out amongst ourselves. And I was hoping for some guidance from you, but I understand your position, I think. So there's no question there. I'm just sort of thinking out loud. Does anyone else have any of the other justices have any questions? Counsel, do you have anything further?
No, Your Honor, we just would respectfully request that the court grant the commission's petition of December 2nd to remand it to the commission to complete its work on or before December 21st.
Okay. Thank you. I do need to speak to the justices after the ending of this hearing. I want to thank you for participating in this. One of the things that we all talked about before we scheduled this is the need for transparency in the judicial branch, and especially with something like this where people may not understand what's going on. So I thank you for participating in this unusual process, but I think it was the right thing to do, and we appreciate that, counsel.
Well, thank you, Your Honor.
So with that, we'll call this hearing to an end. Justices, maybe I'll have Ms. Hamill send you out another link to